Welcome to another episode of the Davidov Wealth Podcast. Today, we're going to be talking about what is it that goes into an estate plan. And so when we're looking at a trust-based estate plan, this is what it would come out at the end. What are all of the different components? What are all of the different documents? And so we're going to talk today a little bit about that. Today I have Ilana and Ethan on there. Let's get started and we'll talk about the first document. Probably the most important document is the trust. Can you tell us a little bit about what goes into that and what's so unique about the trust document?
Sure. That's a great question. Depending on the type of goals that a client has, we're creating whether it's a revocable trust or an irrevocable trust, and we are determining who the trustees are, which means who the decision makers are for you.
So trustees equal decision makers.
Right. And the decision makers have to make decisions based on your goals that you put into the trust. They can't just do what they feel like doing.
Right.
And so if it's a revocable trust, typically the client is also the trustee.
Okay, the one that's setting up the trust.
The one that's setting up the trust is also the trustee, but they're also picking successor trustees. Who's going to be the trustee in the event they're not able to act for themselves?
That makes sense.
And if we're creating an irrevocable trust, such as a Medicaid protection trust, in those cases, clients typically pick maybe their adult children, their sibling, their cousin, someone that they're very close with and can count on as their trustee.
Okay.
Yes.
Can you briefly describe what's the difference between a revocable trust and an irrevocable trust?
Absolutely. So typically a revocable trust is a trust that you set up during your lifetime and you are your own trustee. You can make changes to that trust and you can change who your beneficiaries are. You can change how things are going to be administered, who's going to make decisions for you. You can really change everything about it. When you're creating an irrevocable Medicaid asset protection trust, that's really meant to protect your assets in the event that you need long-term care down the line. In those instances, you cannot be your own trustee. So you select your trustees. But the way that we write up this trust is in a way that allows us to have the creator change who their trustees are if anything comes up and there's a different situation that needs to be managed. So they can change who their trustees are. They can change who their beneficiaries are. So they really remain in control.
So you can fire all of the trustees and hire somebody else
Exactly.
in the event that they're not doing what you want them to.
Exactly. So the goal is to keep the clients in control.
Okay. And not everybody is very comfortable with giving out their trust document, which has all the relevant information about their family and how they're distributing things to their financial institutions. And so we have a different document for that, and that is called a certificate of trust. So it's just a short description of who's in charge, who set up the trust, what the name of the trust is, and whether the trust is revocable or irrevocable, and whether the social security number of the grantor, the person who set it up, should be used for the trust or whether it's something else than that. Ethan, why don't you tell us a little bit about what a healthcare proxy is? It's one of the documents that's in there.
When it comes to a healthcare proxy, when somebody gets incapacitated or hurt in some kind of way and can't make decisions on their own, what typically will happen is the family members expect, oh, I'm the wife, I'm the husband, I'm the daughter, I'm the son. I'm able to go and make decisions on their behalf. That's unfortunately not true. If there's no documentation that before the person is incapacitated, raising their hand saying, hey, guess what? I want this person to make medical decisions for me. If I can't do it, guess what? It's going to be a very long, costly process to do so. So we mentioned a trust and then the certificate of trust. Is there a will involved in these plans as well for any assets outside of the trust?
Absolutely. So a will is an important component of setting up this type of a plan. It is what I would call a little bit of a different will. It's a pour-over will, and it gets its name from what the purpose is. So it is meant to be a safety net in the event that you have assets that you did not transfer into the trust or things became part of the estate after you passed, these are the assets that will get transferred or poured over into the trust through the will. And so in your will, you're going to have one beneficiary, and that's going to be the trust that you just created. And so that will is going to work well with the trust to address those concerns for assets that didn't go into it.
Okay, so in addition to the certificate of trust and the trust that we've talked about, the pour over will that you've explained, we also have the additional documents that are used through an incapacity, such as the power of attorney. That's what's used in case we need to make financial decisions for things that are outside of the trust. So for example, if there is a retirement account, right, that doesn't go into the trust,
Right.
but if we need to be able to manage that, we would use a power of attorney. And I want to make sure and highlight there's a huge difference between the powers of attorney that people sometimes download off the internet and they hope will handle the things that they need handled through an incapacity. Do you want to address that a little bit?
Sure. So there is a big difference, and I look at a power of attorney as being able to give us the tools that we might need down the road in the event of an incapacity for the client. And so power of attorney has to have the right kind of provisions in it to allow for us to have those tools down the road. Those tools would be gifting kind of provisions. And so the powers of attorney that we draft allow us to very broadly to be able to engage in long-term care planning down the road and the ability to set up things and to modify the planning to address the kind of concerns that the person might have. And it's often the case that somebody will come in and say, oh, well, mom already has a power of attorney. And that's great. And when we review that power of attorney, it does not permit us to do the kinds of things that we might need them to do. And so if mom is well enough to be able to sign the documents, she understands it, we'll revise the power of attorney to include those kinds of provisions. But if she doesn't, we might need to do a guardianship proceeding where now we're talking about a court being involved in the case, and that may take some time to address. And so always make sure that an attorney, an elder law attorney, somebody who's skilled in this area of law is drafting that power of attorney for you so that it has the right kind of provisions in there to address it. You mentioned other incapacity documents like healthcare proxy. Do you want to touch on that?
Sure. By having a healthcare proxy drafted, you are selecting an individual that can make healthcare decisions for you in the event of incapacity. People often think that, well, my family is going to make those decisions. Well, what if your family disagrees? And having a person that you designate as that decision maker makes it easier for them to jump in and take action versus needing to get permission to make those decisions for you. So absolutely, that's very important.
Now, can you designate, I understand that you can only designate one person at a time, but can you designate them in succession?
Yes, absolutely. And we often recommend that you pick more than one individual because what if the individual you pick, for whatever reason, is not available? You want to have a backup person to manage your care.
And what's a living will? If you can elaborate on that for our audience.
That's a great question. Many people get confused with the word living will, with the way that it's named. They think that it has something to do with a will that you leave your assets behind.
The last will and testament.
Right, and that's what most people confuse that with. A living will is a document where you basically are saying, in the event that I am incapacitated and I'm not able to make decisions for myself, and I have a terminal condition with no reasonable expectation of recovery, I don't want heroic measures taken to basically prolong my dying process. And so clients feel very strongly about this, either one way or the other. They either want everything humanly possible done to keep them alive as long as possible, or they don't want these prolonged actions taken to prolong their dying process. So we prepare these and we review these in details with clients to make sure that they understand what that means.
This allows for their best wishes to be documented and eventually executed on.
Absolutely. And it takes that difficult decision off of the family members, off of the healthcare proxy agent. They don't need to make a decision not to allow mom or dad to get that antibiotics that's going to keep them dying longer because mom or dad have already made that decision. It's in writing, and that's what's been submitted to the doctors.
Yeah.
So,
Without that, you would need clear, convincing evidence to show that the person wanted this or wanted that. So it's better to have documented that all on the living will, and that would be conclusive evidence to show what your intentions are. So very important document, very important piece of the puzzle. Speaking of an important key to the puzzle, I think the HIPAA authorization, often overlooked, but is one of the most important documents because HIPAA is a federal privacy law that protects your medical information. So you know that when you go to the doctor's office for the first time, the first thing that they make you fill out is here's a HIPAA authorization so that the physician could speak with your insurance carrier to be able to collect the reimbursement rates. But how it plays out in estate planning and elder law is that you want to indicate who's going to be the person who can access information and get information from the doctor to show that maybe there's a health issue and now the power of attorney should be used or now something else should be used. How do we know that you as the trustee are not able to act at that point? So we would have to have permission from the doctor to say, okay, Michael can't act in that capacity anymore because he's not well enough to do that. Without the HIPAA authorization, giving the child or the spouse or somebody else the ability to gather that information, it's not going to be possible. So it's really one of the most important keys to a estate plan.
So do you mean in a revocable trust where their client is their own trustee?
Yeah.
If they don't have the ability, the capacity anymore to act as trustee, you would use the HIPAA authorization to have a doctor write a letter letting you know that this person no longer has capacity and now the next agent needs to step up.
Yeah, it's actually exactly what we're dealing with a case now. We've got a husband and wife who created a revocable trust. The husband passed away since. The wife is now the sole trustee. But as she got older, she's now in her 90s. She is in a rehab facility and has dementia and is unable to act on her behalf. She does have a successor trustee, but we now need the HIPAA authorization to go speak with the doctors, get their certification that this person is no longer able to act as the trustee because of the dementia diagnosis, and that will allow the successor trustees to begin to act for them. So,
Seems like all the tools are put together in order to make the plan work.
absolutely. That's important.
One last document that we didn't mention, disposition of remains.
Yeah, absolutely. Very important document. This has to do with who is the person in charge of the burial or the cremation, whatever the client's choice was. Who's the person who's charged with that responsibility and is charged with the disposition of the person's remains. If you have that document put in place, you've outlined who is that person that's going to be in charge of it and who would be a successor person. Otherwise, there may be on occasion, there are some disagreements with family, particularly when they don't talk about what the wishes are. So we want to make sure that that's clearly outlined in there.
Absolutely.
Good point.
Well, I hope that this was helpful today to talk about
Yeah.
the different tools or the different pieces of the plan that we put together for our client.
Absolutely. It's like the tools of the trade, you know. Can't go to a job site without a hammer to build a roof. You can't go and do estate planning for a client without having these tools in place. Absolutely. Thank you for joining us.
Thank you.
Thank you.